Well, good afternoon. Good afternoon and welcome to another Webinar Wednesday hosted by the Cal State Bakersfield Small Business Development Center. This is Webinar Wednesday number 382. I'm Kelly Bearden. I am the director of the center and your host for today. And we have a great topic today coming up on intellectual property. One thing that every business, it seems, needs, but not all of us understand totally. Well, that's going to change in about an hour. So I think we'll all be experts on it in about an hour. Have Jim Duncan and Ronnie Capaldi from the Young Woolridge Law Office joining us, and we will get to them in just a few minutes. So today we are going to talk about innovation and using intellectual property. We'll talk about the production or the protection and description and uses of key intellectual properties. Why should a small business owner care about IP? And how does it affect your money, your capital, the economy, and also AI? So we'll tie our regular features such as Capital Corridor, Economic Corner, and AI and question mark. And I just wondered how long it would take me to confuse AI and IP. And it's not going to take me long, I guarantee it. So AI and question mark, we'll be talking, of course, about IP. We will have answers to your questions live after today's presentation. So go to the Q&A box and put in any questions that you have, and we will go to those questions. Also, your resources today will be added to the chat box. And if you happen to put a question in the chat box, that's fine. We'll find it. But the resources today, all the resources we discuss will be added to the chat box for your immediate gratification by our webinar producer, Maureen Busher-Dang. And poll questions. Yeah, we've got a few today. So let's go on to the poll questions and see what we have for you today on the poll. So the first question is going to be, based on our topic today, they're going to be based on intellectual properties. So our first poll question is going to be this one. It's going to be which technology will create the most intellectual property over the next decade? Okay, so I'm having you pull out your crystal ball. Is it artificial intelligence? Is it biotechnology, energy? Kern County, the energy capital of California, agricultural technology, robotics, all of them prime opportunities for some really good IP over the next decade. So we have AI, we have biotechnology, we have energy, a lot of things happening in energy, and we have ag tech and also robotics. So you're pulling out your crystal ball today, and 57% of you have responded. Thank you for that. And you're pulling out your crystal ball today, and you're thinking, what is what technology will create the most intellectual property in the next 10 years? And with 64% of you responding, here's your last chance to get in. We're going to go ahead and end the poll and share the results with you. And we do have 64% of you participating, and 67% of you think AI. AI will generate and create the most intellectual property over the next decade. 22% say biotechnology, 11% robotics. And that is poll question number one. So thank you so much. We will now go to poll question number two, and poll question number two is going to be this. It's going to be which intellectual property asset is most valuable to your business? So now let's look at your business and say, is it brand? Is it your trademark or your brand? Is it your consumer list or trade secrets? Is it any copywritten information that you have? Is it patents or are you not sure? So poll question number two is asking which intellectual property asset is most valuable to your business. Number one, is it a brand or trademark? Two, customer list or trade secret, copywritten information or patents, or you're not sure. So we are up to 57% of you that are responded so far. And give you one last chance to jump in to our last final poll question of the day. and it's ended. So what we find is 63% of you are um, most valuable to your business is your trademark or your brand. 13% customer lists. And then we have a nice tie of customer list, patents, and not being sure. So thank you for participating, and let's move on. Okay, so one of the things that we like to talk about here on Webinar Wednesday every week that we have is our capital quarter. And so accessing capital is a vital subject to most small business owners. And so, we had this thing, I think, in the last year or two about the big, beautiful bill. And then I had to show you my big, beautiful bill. And that's it right there. Series 19, circa 1934, the $100,000 bill with Woodrow Wilson. If you have one of those fine beauties, it is truly a big, beautiful bill. It's worth about $2.5 million these days. So, that's it. Our logo for Capital Quarter. And today we're going to talk about a little bit about intellectual property and what intellectual property can do. And one thing it can do to increase the value of your business. And that's one thing I don't think many property owners and many business owners, many asset owners look at is the opportunity for it to increase your business valuation. Having solid intellectual property, having it protected and having good intellectual property can also attract investors. And it can attract strategic partners. So strategic partners would be somebody who might be interested in your particular IP, and that could support, the licensing revenue, or it could be a direct capital investment in your particular business by buying part of it, or even buying your business for your IP. I think we saw that a little bit this week with SpaceX buying Cursor, a company that was only around for about 2.5 years and $60 billion in 2.5 years. Wow, that must be some good IP. So, and it can create also acquisition opportunities. So on the business valuation side of things, when we talk to businesses about how they value their business and how much your business is worth, many entrepreneurs think in terms of the equipment value. They think of inventory. They think of accounts receivable. Those are all tangible assets, but not really thinking too much about intangible assets such as goodwill. But goodwill is one of the things many entrepreneurs will consider as well. But also, if they own IP, the patents, trademarks, copyrights, trade secrets, brands, and software that our experts are going to talk about today, then they can also, actually, jump in there and show some of the intellectual property values. So what we're going to do is I'll show you kind of an example later on of a webinar that we had 10 years ago. But oftentimes you can think in terms of what values you have with those patents, trademarks, copyrights, trade secrets, softwares, and brands. So thinking about something along those lines increases the value of your business when you potentially look to sell. So think of that business valuation for that. Our Capital Summit is coming up, our Eastern Sierra Capital Summit in Mammoth Lakes on July 16th. I'm sure some of this topic will be on that particular thing, and that concludes our capital quarter for today. So on our economic corner, we do have breaking news. We have the Federal Reserve holds interest rates steady, but coming out of there also was that they saw the next rate adjustment could be actually higher as the next move. So that has probably had an effect on the markets since that came out in the last last hour or two. But with the rates being held steady, I think a lot of people were holding out for lower rates. But what we've seen with inflation over the last couple of months is you're going to probably see the Federal Reserve take a very conservative approach on interest rates. And, in our economic corner, we'll talk about a lot of this next week. Our special guest will be CSUB economics professor Niakunde Mecheka. So, Mr. Warsh, Kevin Warsh, on his first Fed meeting. Let me try that again. Kevin Warsh's first Fed meeting today, the central bank signaled that a rate hike is now more likely than a rate cut. So, a little different news than I think a lot of people were expecting. And again, interest rates impact small businesses a lot of different ways. All of our SBA funding, or at least the majority of it, the guaranteed loan program, like the 7As, and other types of lending are variable rate that adjust quarterly based on the prime rate. And when there is a rate change, it does affect the prime rate in most instances. So a lot of other, going down to consumer debt as far as credit cards and other things are affected. And so it's obviously a big deal. So our last regular feature is AI and question mark, our intellectual property accelerator. And just to throw this out, just to get you think about, um, does AI help you accelerate the production of IP? Because you have product design, marketing content, software code. Obviously, with Cursor, $60 billion that SpaceX paid for it. Obviously, software code it does, training materials and videos and other things. So maybe that's the thing we're going to be seeing with AI from a business perspective. As part of your SBDC, America's SBDC's AI U, or AI, we have a number of states that are participating, including right here. Student interns working on AI projects to assist you in your particular business. Other tools here at the SBDC that can help you. Well, there's a ton of them there. I'm going to just focus on, just since I referenced it earlier, on our YouTube channel. So we have right there, our YouTube CSUB SBDC YouTube channel, and we are up to 545 subscribers. Thank you so much for subscribing, and get it dropped into your email each week. We add a new one. There are our most recent ones that are shown there. The thing that is interesting is that the CSUB YouTube channel will host this webinar very soon as well. So, and also, if you go back through and do a little search and you want to see one, we had this one on harvesting intangible assets. And basically, harvesting intangible assets by Andrew Sherman, who's a partner in a Washington, D.C. law firm, has written 25 books on actually covering and finding hidden revenue from your company's intellectual properties. You want to see a dated version of Webinar Wednesday? There it is, right there. Actually, the virtual brown bag was a monthly webinar that we did once a month instead of Webinar Wednesday for the entire Central California region. And you'll see the sponsors below, a number of fine educational institutions here in Central California. So that's available if you want more information on this particular topic. That event is gone. So if you want to contact us for confidential, no cost, no obligation expert consulting, you can go to our website, csubsbdc.com, and sign up for services and meet with one of our advisors. Here's what's coming up on Webinar Wednesday. As I mentioned, Nikunde Mecheka is coming up on the 24th. On July 1st, we're going to do a special 250 years on U.S. small business opportunity. Don't miss it. July 8th, we'll have Megan Hudap who's the small business manager of iBank, which is the California Infrastructure and Economic Bank. Great loan programs through the iBank. So that's what's coming up on Webinar Wednesday. Again, thank you to our fine sponsors. Greatly appreciate the opportunity to be here and introduce this team. Our special guests today are Jim Duncan and Ronnie Capaldi. Let's start with Jim. He's an intellectual property attorney and partner at Young Woolridge. Grew up in Pasadena, met his wife Nancy in high school, serving 3 years for the U.S. Army in the 9th Infantry Division. Thank you, Jim. And also attending the New Mexico Institute of Mining and Technology. I've heard a lot about that institution as far as getting his bachelor's in petroleum engineering, moved to Bakersfield. Years later, became a patent attorney here. It's the only patent attorney I know of in the city of Bakersfield at this time. And so Jim has crafted this business over a long period of time. Ronnie Capaldi is an associate attorney in the business department at Woolridge, focuses on the prosecution of patents and trademark applications. Bakersfield native, North High grad, CSUB. Thank you for being a fine runner over those years with that Bachelor of Science in Chemistry. Spent 8 years in a clinical lab as a scientist, experience that led him into intellectual property law. Attended Pepperdine Law, and now he's here on Webinar Wednesday. So let's turn it over, first of all, to Jim Duncan. Thanks for joining us, Jim, and take it away.
Very good. Well, I am not going to have the Kelly Bearden radio announcer voice. He's got that down pretty well, so I will do the best I can with that. First, let me tell you a little bit about what it takes to be a patent attorney as opposed to just a regular attorney. Uh, Patent attorneys, unlike other areas of the law, require the attorney to be admitted to the United States Patent and Trademark Office if they wish to prosecute patent applications. And by prosecute patent applications, I mean prepare them and then file them with the patent office and then go through the whole process of trying to secure a patent in that process. In order to be admitted to the United States Patent and Trademark Office, you're required to have a technical undergraduate degree, which is one reason most lawyers are not patent attorneys. Most lawyers are going to have a political science degree or something like that. So that really reduces the number of patent attorneys that are available. As Kelly said, I believe right now I'm currently the only full-time patent attorney in Bakersfield. Ronnie will be shortly because he's studying even today for the patent bar. I'm going to have Ronnie just briefly discuss what that is like and what is tested on in the patent bar.
Hello, everyone. Thanks, Jim. Thanks, Kelly. So yeah, as Jim said, I am currently studying for the patent bar. It is a requirement to practice before the United States Patent and Trademark Office, commonly referred to as the USPTO. And it is only required to submit patents to the office, not to practice trademark law. Um, the reason why is patent law is very technical and deadline driven. And as Jim said, one of the requirements is to have a technical or scientific background to be able to qualify. So the patent bar really is focused on testing your knowledge of what is called the MPEP, and that stands for the Manual of Patenting and Examining Procedure. The MPEP is a culmination of congressional law, very statute heavy, federal rules, and it's all put together in kind of a manual, a procedural way. It's intended to be an easier culmination of all that information, if you believe that. So, the MPEP really focuses on the patent application procedure, claim drafting strategy, deadlines, office action responses, which are really just how you communicate with an examiner at the USPTO while you are getting an application prosecuted. And so, these things really matter for a small business because, patents can be an important business asset. But like I said, the process is highly technical and deadline driven. So, having this knowledge of the MPEP is really important for, the procedural side of protecting innovation, when to file, how applications are examined, how rejections are handled, and why patent strategy can make a real difference for entrepreneurs and their business. So yeah, as Jim said, I'm not registered yet, hoping that will change soon. But it is a pretty intense exam. And to add to what Jim said, there are not very many patent attorneys out there. I think the latest update is there's about 1 million attorneys nationwide, if I remember that correctly. But patents only make up about 40 to 50,000 of those attorneys, and that's nationwide. So yeah, Jim currently is the only one in Bakersfield, but hopefully that will change soon when I pass this exam. So I'm going to hand it over to Jim.
Very good. Well, thank you, Ronnie. And I feel for him. Both of us have taken and passed the California bar exam. I think we both did it our first time. Uh, the patent bar, the first time I took it, it was grueling and it had a pass rate of about 30% or lower the first time I took it. And I had to take it a second time to get through it. So it is not an easy exam. Well, let's go ahead and get on to our topic for today. First of all, let's talk about what intellectual property is, in general. And intellectual property is refers to creations of a mind, such as inventions, literary and artistic works, uh, designs, symbols, names, and images used in commerce. These are all intangible assets, which, to the extent they can be protected, fall within specific silos of protection. And the one thing I really want to get across to you is that aside from these silos of protection, the United States is an open market competition. So on this slide, you're seeing the 5 different categories of intellectual property that can be protected. And they all have various limitations and various benefits and negatives that go with them as well. But by and large, these are the silos of protection that you can obtain. So first of all, let's talk about trade secret. It's any formula, pattern, device, or compilation of information not generally known in the trade, and it has economic value from the fact that it is not generally known or ascertainable. Now, the name trade secret is exactly what it says. It needs to remain a secret. To the extent that it's publicly disclosed, it is no longer protected under trade secret. So the right that is possessed is, so long as it's maintained in secret and not made public, the owner is entitled to protection from having the trade secret stolen or misappropriated. Now, it does not develop or does not protect the owner from independent development of that particular process or composition. So, for example, the owners of Pepsi-Cola are perfectly entitled to go out and buy as much Coca-Cola as they want and subject it to extensive analysis and try and figure out the recipe for Coca-Cola. And that is perfectly legal. What they cannot do, first of all, and obviously, they cannot break into the Coca-Cola safe and steal the formula and use it that way. More commonly, what they cannot do is hire the chief chemist from Coca-Cola and have that person convey to them the recipe for it. And that's one of the most important points about protection of trade secret information, is that you control those who have access to the information. And so, for example, with employees, any employee that's going to have access to company trade secret information needs to have signed an agreement with the company, which prevents them from disclosing that information. And here are some examples of it. I already gave the example of Coca-Cola, the Colonel Sanders 21 secret herbs and spices, customer lists. Computer software can be trade secret if it's code that is maintained on a private server and is not publicly available. And various manufacturing methods can also be protected under trade secret. So moving on to copyright. And I will tell you, and I had this conversation with Ronnie, most lawyers, when you ask them about what's the difference between copyright and trademark, they will have a difficult time telling you what it is. Well, I'm going to try and clear up that mystery. Copyright is exactly what it says. It gives you the right to prevent others from copying your original works of authorship. It's got to be fixed in a tangible medium of expression, meaning it's been photographed, it's been written down, it's been videoed or taped, some sort of tangible way of memorializing that information. And it is administered by the Library of Congress, which administers registration for trade or copyrights. The term of protection begins as soon as the work is fixed in the tangible medium of expression. So if you're standing on the edge of a Grand Canyon and you take the photograph of a lifetime, as soon as you've taken that photograph, you own the copyright in that work. Now, if you have someone standing right next to you and they take the exact same photograph with the same lighting and everything else, they own the copyright in the photo that they've taken, and you cannot stop them from profiting from their photograph. Uh, the, the protection for the copyright for an individual is 70 years after the author's death, and for works made for hire, and that's works that are made for an employer. So if you have Walt Disney Company and they have people that create uh, images for them, create content that is protected under copyright, that's going to last for a term of 95 years from the date or from the year of first publication. And publication is a legal term of art. And when something is published, it essentially means that it's been made, released to the public, and the public has access to it. And it's a term that is quite important when it comes to copyright. And the reason for that is that on this slide, you'll see that registration is required in order to bring an action for copyright infringement. And so and there's various benefits to registering earlier rather than later. If you register the work before it is infringed or within 3 months after the work has been published, you're entitled to all of the benefits that come in the copyright enforcement, all the remedies that are available, which might include enhanced damages, attorney's fees, and some just very powerful things. And if you wait until after the infringement has occurred, ordinarily you are not allowed to recover attorney's fees or enhanced damages, which might be 3 times the amount of the actual damage or something like that. Okay, moving on to trademarks. And again, these are often confused by lay people as being with copyrights, but a trademark is actually a way of a source identifier. It's a way of telling or distinguishing between one company's products and services and those of the other. I mean, we run into them all the time, and their value is that the trademark is why people will make a particular purchasing decision. If you're walking through the grocery store and you're trying to decide on a particular soft drink to buy, and you see Coca-Cola on one shelf, and then you see the generic cola brand on the other, people are willing to pay more to buy the Coca-Cola because of its reputation for quality. They're familiar with it, and they associate that trademark with the product. The rights that trademark provides is it gives you the right to exclude others from using trademarks or service marks which are confusingly similar, and to prevent others from diluting or tarnishing the trademark. Now, when I say that confusingly similar, that's almost always the crux of any infringement action, is how close does it have to be? And there's not an objective standard that establishes that. It is a subjective decision, and in fact, it's a question of fact for a jury to decide whether or not a trademark is confusingly similar. So it does. If you use just a little bit, and I've heard people say, gee, if I vary the mark by 5%, will I avoid infringement? And I cannot say that. It all depends. If you if you misappropriate the most memorable part of a mark, chances are you're going to run into a problem with infringement. Because again, what you're doing when you infringe someone's trademark, you're essentially benefiting off of the goodwill that they've established in a trademark through their reputation, through the advertising that they've paid for, and it's just a very valuable right for them. I think I've heard that the estimated value of the Coca-Cola brand is in the billions of dollars. And again, the trademarks allow consumers to identify and distinguish the source or provider of different products. And they're a form of consumer protection. Again, it's because they allow a consumer to distinguish between different products. They know what the consumer comes in knowing what to expect. And it's why the trademark office is very diligent in examining applications for trademark registration, because they're trying to avoid consumer confusion. So you've seen the circle R. The circle R is a symbol from the trademark office that means a particular work is registered, and it can only be used by marks which have been registered by the United States Patent and Trademark Office. You may not use a Circle R if you do not have a registration. Now, however, what you can do is you can use the TM and SM superscripts. It's perfectly fine for your business if you don't have a registered trademark to put the superscript TM or SM next to that mark. And all you're doing is telling the world that you are claiming trademark rights in that particular mark. So trademark, unlike patents and unlike copyright, are protected as long as the trademark is actually used. And when we're talking about registration, the registration can go on forever as long as you continue to renew it and show that you're continuing to use the trademark. And this is unlike patents and copyrights, which both have a finite term. And so enforcement of a trademark is done in a civil action filed in federal court or state court for trademark infringement. And again, if you have federal registration of a trademark, it provides additional benefits as far as the remedies that you have available to you, like copyright infringement. For a registered copyright, federal registration allows you the potential recovery of attorney's fees and enhanced damages. And I will tell you, if I have someone come in and they've gotten a cease and desist letter from an attorney and the attorney does not provide a registration number, or if we ascertain that the mark that they are saying is being infringed upon is not registered, that takes an awful lot of the fear away from that cease and desist letter. If it's a registered mark, it provides a whole new level of anxiety because of the various remedies that are provided under the trademark law. So I was talking earlier about likelihood of confusion. And there's a number of factors that go into that. In California, in the Ninth Circuit, there's actually 9 different factors that go into that determination of whether or not there's a likelihood of confusion. And I provided here 6 of those various factors. And I refer here to similarity of a marks. That's perhaps the closest, or probably the most important of those, along with relatedness of the goods or services. So let's talk about that for a moment. And I also refer to strength of the mark. If you have a particular mark that is used in one area of business, and then it's used by someone else for a completely unrelated area of business, in all likelihood, there's not a likelihood of confusion. So for example, the trademark McDonald's is an extremely strong trademark for fast food services, restaurant services. I mean, if I opened up any restaurant at all and I have a Mick in that name at all, I've got a real risk of being gone after by McDonald's because of how strong that trademark is. Now, on the other hand, if I open a transmission shop and I call it McDonald's Transmission Shop, chances are I'm going to be fine because, first of all, the name McDonald's is a surname, so it's not a particularly strong trademark apart from its use for fast food services. And so in all likelihood, I would be safe. Now that goes, again, that strength of the mark means that mark is able to cut across the lines of usage. And so, and I'm going to have here is some of the indicators, or it's a spectrum of trademark strength. And it goes from here, the coined words, they are the strongest trademarks. They're provided the greatest protection. They are made up names, and Google would be added in there now as well. And then at the very bottom, you have generic, and you have some of the things shown there, aspirin, escalator, kerosene, all of those things at one time were registered trademarks. But what happens is, as the trademark comes into being used synonymously with the product, you run the risk of committing genericide, meaning that the trademark is come to be thought of as exactly the same as the product. And so you had some very common trademarks, for example, Kleenex or Xerox. Both of those marks came very close to committing genericide, meaning because people would say things like, hand me a Kleenex, or would you, make a Xerox of that for me. And the trademark owners, what they do to prevent that, they go on to be very specific and say, no, this is our brand. And so when you hear Kleenex advertised, they will say Kleenex brand facial tissue, or you will have Xerox say Xerox brand copiers. And what they're doing is they're saying, look, there's a difference between our brand and our product. And so that can be very important. And you don't want to, even though you think, well, this is great, the consuming public associates our particular brand with the product itself, that actually can be dangerous. Going back to strength of the marks, you have arbitrary usage. So you have Camel for cigarettes, which is, I guess, pretty old now, but Shell for oil products, Arm and Hammer, things like that. They really have nothing to do with the product itself. The next level on the spectrum is suggestive words. Ivory Snow for laundry detergent, Raid for insecticides, Pampers for disposable diapers, and so on. And then you get into descriptive. And these are where the name really starts to talk a lot about what the particular good or service is. And generally, those are given the least amount of protection. And if you apply for registration of a mark that the trademark examiner concludes is too descriptive, it's going to be refused. They say, no, we're not going to take words out of it, common vernacular, so you can use them in your trademark. And they will often require you to disclaim certain terms of your mark. Now, you can overcome that with extensive advertising and showing over the years that the public has associated your particular brand with your product. And so you have things like Budget Rent-A-Car, which started off being a very descriptive mark, but through their advertising, nowadays people recognize that Budget Rent-A-Car is a very discreet brand, and it's one that they will view as being an alternative to Hertz or Avis or the others that are out there. Switch now to and what I think it might be the most important area of interest to those that are watching this webinar, and that is patent protection. And there are actually various types of patent. Ordinarily, when you hear the term patent, normally people are thinking of utility patent, whether they know that or not, because a utility patent generally provides the strongest protection of all the different types of patents. The other two being design patent and plant patent. Plant patents protect asexually reproducible plants. So if a new rose is developed through grafting, that can be protected by plant patent. A new variety of grape, which can be developed through grafting, that can be protected under plant patent, and they can be extremely valuable. But again, they are very specific and ordinarily not the types of patents that we're referring to. Design patents, the name always sounds great. You go, yeah, that's exactly what I want to do, is protect my design. Well, they're actually fairly limited in their protection. They protect the ornamental design of an article. So yeah, I have the example of a beverage bottle. I think one of the more interesting ones, and this Apple has a design patent for the shape of the iPhone and for the iPad. And that actually turned out to be quite valuable because they were in litigation with Android, I can't remember, Samsung, in litigation with Samsung. And, in the jury and on all the questions on patent infringement are determined by a jury. And so you have lay people that are trying to understand these very technical patents. They're, of course, explained to them by an expert, but at the end of the day, they have to make a determination as whether or not the plaintiff's patent was infringed. And so in the case of the Apple and Sam case, one of the things that was quite important is the jury did find that the Apple's design patent had been infringed. And I think part of that is just because that's finally an issue that the jury could actually understand and say, oh yeah, we can see that. But generally speaking, the most powerful protection is provided by a utility patent, because a utility patent protects functionality. It looks at the particular process or machine, article of manufacture, and looks, okay, what is going into this, and it generally, as I said, provides the most protection. The rights protected under patent are the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. Now, the term claimed invention is a term of legal art. It means the legal definition of the invention. And so when you're talking about a patent, if you've seen one, the patent has basically three parts. It's going to have the drawings, it's going to have a written description, and it's going to have the claims. And ordinarily, you get a cease and desist letter from someone, and they send you a copy of the patent, and the item shown on the drawings looks identical to yours. That's going to make you quite nervous. However, with a patent attorney, what we will do is if one of our clients gets a cease and desist letter for infringement, the first place we go to is the claims. And the claims, as I said, are the legal definition of the invention. So if we go back to the old classic widget and say you've invented a widget and you have to write a claim for it. And you go to your patent attorney and say, here, I've got this great new and improved widget. And the patent attorney looks at it and says, that's great. And so I'm going to use this as an example for how this process works. So the inventor has a claim for that widget, and you say it's a widget that comprises elements A plus B plus C. Now, the word comprising is a term of legal art, and it means in order to have that invention, at a minimum, you have to have the following elements. And it can actually, it means that if somebody adds to it, they could still be infringing. So notice there it says that, owning a patent does not necessarily give the owner the right to make the invention. And that is because the patent office may allow a patent which meets the requirements for patentability, but it nevertheless infringes someone else's patent. And that's probably a topic for another day, but that's important to realize. But so going back to the widget example, though, so you've gone to your patent attorney and he's written a claim for a widget having elements A plus B plus C, and he writes and files a patent application. That patent application goes to the patent office and it sits in the queue at the patent office. And I'm going to give you some of the information about that. You file that application, and you can file what's called a provisional application, or you can file a non-provisional application. If you file a provisional application, that is merely a disclosure document that is filed to say, hey, I have invented this, and here it is. And when you file that provisional application, it gives you a priority date. But that provisional application is never actually examined by the patent office. The most important thing is they make sure that you submitted the correct fee and that you have submitted something that looks like a patent application, and that's as far as it goes. They do not examine that provisional application. In order to claim priority to that provisional application, no more than 12 months after the filing date of a provisional application, you have to file a non-provisional application that claims priority to your original application. And so once you filed that non-provisional application, you're going to get in the queue for examination. Right now, the patent office is running about a 24-month lead time up to examination. And that's from the time you file the application to the first examination by an examiner. Now it's going to go through the office, preliminary examination, and that just makes sure that, okay, again, you filed the fee, but you have something that looks like a patent application, you've submitted the necessary documentation, but it is not substantively examined until a patent examiner actually gets it and examines it. Now you're going to get, if you are 65 plus, you can get accelerated examination, meaning that the patent office agrees to examine it within 12 months. So if you are 65 plus, it's very much to your benefit to go ahead and file the petition for accelerated examination. So going back to the widget example, the examiner gets that patent application, and he's going to turn right to the claims ordinarily. He's going to look at the drawings and the specification to make sure that what is in the claims is actually supported by the drawings and the specification. But primarily the fight on patent applications are what is allowable in the claims. And that's always where the fight lies with the patent examiner. So they're going to review that. They're going to do first a search to see, okay, well, prior to that, they're going to say, is this a patentable subject matter? Now, patentable subject matter essentially means that it has to fall within the statutory definition or statutory provisions that allow something to be patented. And pretty much every useful device can be patented. Things that cannot be is perpetual motion machines cannot be patented just because they don't work. Nuclear weapons, the last I heard, cannot be patented. And then you have just living organisms, things, inventions, so to speak, of nature, by and large, cannot be patented. However, there's some, when you have things that are done through gene splicing, those organisms can be protected. And so those are things that typically you're going to discuss with a patent attorney before you ever file the application. One of the other areas where it can get really interesting on patentable subject matter is when you're talking about method patents and you're talking about methods that utilize a digital processor for the method. And there are some decisions from the United States Supreme Court that have really laid up a framework that has to be complied with before you can get a method patent through. And one of the reasons for that is in years gone by, there were some real junk patents that were issued for method patents. There was one that will always be in my mind. It was a method of entertaining a cat, or a method of exercising a cat. And it was essentially taking a laser light fob and dancing the beam around and getting the cat to chase it around. And they actually issued a patent for that. So they have now improved from allowing that type of patent. So patent examiner, now we're going back, he's examined it for your widget. He's got a widget comprising elements A plus B plus C. He's going to do his examination. And suppose he finds a widget that has elements A and B, and he finds a patent for another widget that has elements C plus D. Well, the first substantive requirement for gaining a patent is it has to be novel, meaning that no other invention in the world, known invention in the world, is there that would prevent you from getting a patent. And typically that's determined by published documents. So any publication in the world, no matter where it is, it can be grounds or it can be prior art, which would keep you from getting a patent. Now, typically what the examiners do, they look at issued US patents, published patent applications, and also the patents from foreign countries. All of those are fair game for the patent examiner to refer to. And it doesn't matter if the patent is expired. A patent that's 200 years old can still be used as prior art against you. So now assume that with this example of a widget, he's found those two patents, one with A plus B and the other with C plus D. If the examiner then says, okay, there's nothing like that, it meets the novelty requirement. So the next step is the examiner has to make a determination of whether or not what you have done, your claimed invention, is obvious given the prior art that's already in existence. And it's obvious to one who is skilled in the art of the invention at the time of the filing of your application. The way an examiner determines that ordinarily is they look at what's already out there and say he's found these two patents for a widget, one with A and B and another with C and D. It's not at all uncommon for an examiner to say, it would have been obvious to one skilled in the art of the invention at the time the application was filed to combine those two patents to arrive at your claimed invention. And there's ways of arguing against that. And so let me now talk a little bit about that prosecution process. So that examiner, he finds those two and he issues an office action saying that it would have been obvious to someone skilled in the art of the invention to combine those two patents to arrive at your invention. And then he's going to issue this thing called an office action that Ronnie referred to earlier. And it's going to give the inventor up to 6 months to respond to that office action. However, that if you want to do it without having to buy an extension, you've got to file a response within 3 months. And so this is one of the big issues that with patent attorneys, we're maintaining our docket. I don't know how many different open cases we have right now, but it's a lot. And you're always having to track those deadlines and make sure that you do not miss a filing deadline. And they are very strict about it. If you file a response that is 1 day late, either you're going to have to pay a surcharge for that, or it's going to go abandoned, and then you're going to have a real problem getting it revived. So there's reasons to get that thing filed. Now, the way that we respond to an office action, first of all, we can argue with the examiner that the combination that they have suggested is not physically possible, or even that the references themselves teach away from making that combination. And if you can do that, then you've overcome that refusal. The second way we get around it is by amending the application to include limitations that were not included in the original application, or pardon me, that were not included in the original claims, but they have to be disclosed in the application. So if we go back to the widget comprising elements A plus B plus C plus D, say that you also had disclosed an element E in your application, well, you might be able to get around the refusal by coming back and saying, okay, I'm going to add in the claim. I'm going to say a widget comprising elements A plus B plus C plus D plus E. And that sometimes that will work in terms of overcoming that refusal. Goes back to the Patent and Trademark Office. The examiner considers your response, and either he is going to, oh, happy day, you've overcome it, and he's going to allow the case, or he's going to look at it and he might do a new search and find new prior art, find a prior art reference that teaches a widget with element E, and he'll issue what's called a final refusal. And then he issues that. Now, when you say final refusal, there are great ramifications of that. It means that you have very limited ability to how you're going to respond to it. But the beautiful thing in the patent office is if you're willing to spend the money, you can always start over again by filing something called a request for continued examination. And so it can be very expensive, but there are ways of keeping a patent application pending pretty much forever if you're willing to pay the money for it. So one of the things that I wanted to also address is when a patent application is filed now, it is normally published 18 months after the priority date. So say you filed a provisional application on June 15th of 2025. That means that by no later than June 15th, 2026, you have better filed a non-provisional patent application in order to claim priority. And then what will happen is 6 months after that, so again, 18 months after your original filing date, on, if I'm counting correctly, December 15th, 2026, your patent application is actually going to be published. Once a patent application is published, it's publicly available for anyone to get into the patent office files and see exactly what's in that application and see whether or not you're having issues with the patent office in getting the application through. Now you can, if you are not going to seek protection outside the United States, at the time the non-provisional application is filed, you can request non-publication. By doing that, no one can get into that application, period, until either the application issues as a patent, and actually that's the only time they can get into it, is when it issues as a patent. If you've had real problems there and you requested non-publication, you can actually prevent anyone from actually seeing what you filed if ultimately you have to abandon that application. So I see we're getting short on time, and okay, so yeah, but term of patent protection for utility patents, it's 20 years from the effective filing date of the parent application. Design patents, it's 15 years from the date of issuance. Plant patents, 20 years from the effective filing date. Enforcement of patents means you're going to federal court. That's the only courts you can go and file an action for patent infringement. And a very important point, patent protection is territorial, meaning that you only have protection in the countries in which you have a patent issue. So when you have a United States patent issue, that gives you the right to exclude others from making, using, selling, or importing the claimed invention in the United States. That does not stop someone for, say, example, making that invention in China and selling it in China, just so long as they don't try to bring it in the United States. You can obtain protection outside the United States through a variety of processes. And what you can do is file a patent cooperation treaty application, known as an international application, that must be filed within no more than 1 year from the filing date of your priority document. Meaning if you file the provisional application, that patent cooperation treaty application has to be filed within 12 months of the filing of the provisional application. I think I've gone through all these. Yes, you need to provide an enabling disclosure, meaning that you must provide a sufficiently detailed description of the invention to enable a person having ordinary skill in the art to make and practice the invention. You cannot generally keep the crown jewels to yourself. If you're going to seek a patent, you've got to disclose it all and you have to enable it. And then again, the protection outside the United States with the treaties that it has, you can file outside the United States. And so long as you file within 1 year of your original US application, you can claim priority to your US application. Yeah, I was talking about the PCT. This slide shows the information on the PCT application.
Fantastic stuff. Wow, that's a lot of information. Some great information. So now let's jump and see if you have some questions that you have. So let's stop the share here, Jim, and come up here and see what's now going on as far as questions go. So jumping into the questions that we have, first of all, for a patent, medical, and athletic footwear startup, when pivoting from early localized surveys to macro market data like CDC, National Demographic Statistics, what is the best way to present this higher level data to satisfy state innovation grants such as Cal OSHA? Oh, you're going to hand that one off to me?
You're more in the funding side of things than I am, Kelly.
That is true. That is an question I cannot answer right now. But April, we will get back with you on that and look into that, and I will find out information from the California Office of the Small Business Advocate and see exactly what is the best way to present the higher level data to satisfy the state innovation grants. Can services be protected as a trade secret? Come on in here, Jim. Don't be shy.
They can to a certain extent. If you have, say, a particular formula that you're using for a particular purpose, whether it's something that is used for like cleaning a swimming pool or something like that. You have a pool cleaning service. If you come up with that cleaner and you're applying it on the job as you're doing it, that's going to be a protectable trade secret. Now, if you need to maintain it in secret, meaning that you don't divulge the formula to someone, that you don't write articles about it, and you don't really make that particular substance available for someone else to be able to get a sample of and reverse engineer. So again, it all comes down to, are you taking the correct safeguards to treat it as a trade secret? And ordinarily in a trade secret case, the number one defense is that the owner of it really didn't treat it as a trade secret. They were publicizing information about it, or they did not have non-disclosure agreements with their employees and that sort of thing.
Let me take that one step farther. Get back in here, Tim. Right. Let me take that one step farther. So that answer you gave was an example of having a product that they invented to clean that pool.
Mm-hmm.
What if it is a technique, a service technique that is without a product? Is there a service aspect of that can be a trade secret?
You can, so long as you're doing it in an environment where the confidentiality is going to be maintained. So for example, if you repair shoes and somebody brings them into you and you have a trade secret method of repairing them and it's done all within the confines of your business, certainly that can be protectable.
Great. Okay, let's hit the chat box, see if we got anything in there. We'll give you another couple minutes to, or another couple of seconds to throw a question in there. But jumping into our webinar chat box, thank you, Maureen. And the greetings and salutations start off, a little reference to our SBDC, CSUB SBDC YouTube channel. You want to start a business, there's some patent information. You want to contact Jim. There's a phone number and an email address. And Brian has a question in here. So, after being issued a patent, is there a time limit to notify an infringer and a time limit for filing an infringement suit against such infringer?
Great question. And I recognize Brian, and so hi, Brian.
Hey, I do too. Brian, good to see you.
Once the patent issues, you want to provide prompt notice to the infringer. Now, there are, and one of the reasons is that the later that you wait to notify the infringer of the infringement, the greater argument there is that you've not been damaged, or any damages that occurred prior to notice are not going to be recognized. So that's one reason to notify them. And there are, and Ronnie, you might know this better than I right now, in terms of statute of limitations on patent claims. I think that they're going to be cut off after a certain number of years.
I don't know what it is.
Yeah, there is a statute of limitations that fortunately, I have not had to file a patent infringement case for some time, so I have not needed to look at the statute. But it is something that you always need to be aware that there is a doctrine called latches, meaning that you just can't sit on your rights. You have to seek to enforce them. And then there potentially also is, and I'm pretty sure there is, a statute of limitations on when you have to actually bring a claim for patent infringement once you become aware of it.
6 years.
Yeah. I'm told by Ronnie that 6 years.
6 years. Wow. Okay, I don't see any other questions. Jim, fantastic information. Ronnie, thank you so much. Great to have you here. Great to have another patent attorney coming to town, I should say. So, for Ronnie Capaldi and Jim Duncan, I'm Kelly Bearden. We'll be back next week with Webinar Wednesday 383, again with Niakunde Macheka. We'll be talking economics and a lot of the stuff today. Everybody have a great day. We'll see you next week. So long, everybody.